The Corrections Department's been accused of wanting to have its cake and eat it too when it comes to compensating prisoners held in jail for longer than they should have been. In September last year, the Supreme Court ruled the Corrections Department had been incorrectly calculating release dates for some prisoners. One inmate, Shane Gardiner, was released the following day, and many others were affected by the decision. And today, Mr Gardiner's lawyers asked the High Court to order the department to compensate him. Our court reporter Anne-Marie May was at the hearing and she joins us now in our Wellington studio. Evening, Annie. What other points did Shane Gardiner's lawyers raise?
Hi, Rowan. Well, Douglas Ewan said that when they're calculating this sort of compensation, they could use the same formula that's used when someone is imprisoned and then exonerated, for example, like what happened to Taina Pora, and that would lead to between 14 and 15,000 for his client, Mr Gardiner. Corrections said it had been open to Shane Gardiner to actually take action himself while he was in prison. He could have asked the prison inspectorate or the ombudsman to take a look at his case and work out how long he had been held for and whether it was right or wrong. Douglas Ewan said that would have been an exercise in futility. He said the department had felt constrained and unable to act until it received that Supreme Court decision. Mr Ewan also said that for Corrections to suggest his client shouldn't receive the same amount of compensation as would be paid to someone who had never been in jail was wrong in principle. He said that created classes of deserving and undeserving recipients of such compensation.
And Anne-Marie, how did the Corrections Department respond to those matters?
Well, we actually heard from a member of the Corrections Department's executive, Rachel Lealta. She said that great care is taken to ensure that prisoners' release dates are correctly calculated. She said until last year's Supreme Court ruling, they had been doing that in line with an earlier Court of Appeal decision, and they couldn't change that until it was overruled by a higher court. In response to a question from Mr Ewan, Rachel Lealta said that Corrections still doesn't have a final figure as to how many people might have been held for longer than they should have been since 2003, when that previous way of calculating release dates was implemented by the Court of Appeal. Corrections lawyer Daniel Perkins said there also had to be some consideration of whether there was any claim by victims of Mr Gardiner's offending under the Prisoners and Victims Claims legislation.
And what's due to happen next, Anne-Marie?
Well, Justice Cunningham reserved her decision today. There are several other cases, Rowan, that are sort of on hold, waiting to see what happens in this case. And if Justice Cunningham rules in favour of Shane Gardiner, those other cases will be activated. Corrections has also appealed against a High Court decision last year. That was a decision in which Justice Simon France said that the Supreme Court ruling had to apply retrospectively. It couldn't just affect future cases. That appeal has also now been put on hold pending today's decision, and whatever happens with that, if it goes against Corrections, there's likely to be one big appeal hearing that will cover all of those issues.
Thanks very much for that, Anne-Marie. That's our Wellington court reporter, Anne-Marie May.